The topic is opening statements. The speaker is Howard Hershenhorn.
In any event, ladies and gentlemen, I am going to do these opening statements in our fact pattern as quickly as I can without speaking too quickly, but hoping to keep everybody so that you can have your proper lunch hour and do whatever business it is that you are required to do during that hour, including eating your lunch and coming back for the afternoon section. I want to just talk very briefly about opening statements in general in a construction accident labor law case. And what I want to say is that I think the most important thing that you can do as a plaintiff or as a defendant is to remember that during your presentation of your opening statement, your first time that you can really speak freely to the jury about the case within some confines of the law, to do everything you can to use the legal terminology that the jury will hear at the end of the case. So, you've learned a lot today. When Lisa and Tony spoke earlier, you've learned about the new law that is being talked about in appellate division case after appellate division case, and the wording in that law about normal and logical response. Well, as Tony told you, that law was created in that Court of Appeals case that we talked about earlier. That law has been, it really was dicta in that Court of Appeals decision, but it's been grabbed by many appellate division judges, particularly Judge McGuire in this Cherry case. And if you, as the lawyer, can begin to use some of those words, later on, when the jury hears the charge, which will inevitably include some of those words, you've done two things. First, you've gained a tremendous amount of credibility with the jury, because while you're not allowed to tell them the law, you've used those words in your own way. You've stolen the judge's charge in a nice fashion. You've taken it for yourself, and you've gained a tremendous amount of credibility with the jury. And the second thing is that those buzzwords that you have discussed with the jury will be things that are important in your appellate record. And so it's important that while you're developing the testimony, whether it be through the expert, through the site safety foreman, whoever it is, that you use the words that you know the court is later going to rely upon. So you've got the normal and logical response. If there is an issue of recalcitrance or sole proximate cause, there you've got the words, a clear and direct instruction. It can't just be a general instruction. It has to be a clear and direct instruction. For example, to use a particular safety device, to not use a particular device in a certain manner. And finally, the most important words, I think, particularly in this fact pattern, but really in every case I try, the most important words to mimic as a plaintiff's lawyer are the words a substantial factor. A substantial factor. Not the, but a substantial factor. So that when you get to a case like this, if the jury were to determine that the defendant's negligence was a substantial factor, it really is the end of the case, because there cannot be any comparative. So you should be using those words all the time, and I think it will really help you in terms of your credibility with the jury and in all the ways that I just discussed. So let me start out with the opening statements, and I have the privilege of doing the openings for both the plaintiff and the defendant. I'll obviously start out with the plaintiff, and I will then go directly into the defendant's opening, and again, I will try to move through them relatively quickly. May it please the court. Your Honor, ladies and gentlemen of the jury, there is one consideration that is of paramount importance on any construction site in the city of New York. And that consideration is the safety of the workers, the men and the women who build the buildings, who build the bridges and the tunnels that we, every single one of us, take for granted on a daily basis. Ladies and gentlemen, we have brought this case under very special laws that our legislature has carved out in order to protect construction workers who work on construction sites that are wrought with danger, who climb scaffolds and ladders and operate cranes and work at heights that when we pass by those construction sites, we say, oh, look at that guy up there. We don't know how that person has gotten up there. Well, our legislature has seen fit to protect those people who risk their lives on a daily basis to build the buildings and the schools and all of the other places that we utilize. And ladies and gentlemen, the evidence in this case will show that those labor laws were violated in this case. Those labor laws were violated by the defendant, owner of this building, Duncan Properties, and the general contractor, Crispy Construction. And we will show you, through the evidence in this case, that those violations of the labor law, those violations were a substantial factor in causing first the injury and then the death of a young man who had a wife and 2 small children. Let me tell you a little bit about the site. And I'll back up to tell you, the accident happened, as I told you in jury selection, back in August of 2007. And it happened when my client's decedent, Victor Crumble, was working to help build a skyscraper on 45th and 1st Avenue. And during the process of the building of this skyscraper, Mr. Crumble, who was a carpenter and who had only been on that particular job for about 3 weeks, and who had only really been in the construction industry for a short period of time, Mr. Crumble's job on that day was to put sheetrock in or onto the ceiling. And on this at this particular time, the part of the construction of the building that was going on were the 3rd through the 8th floors. That was the part of the construction that Mr. Crumble was involved in. And in order for him to do his work, Mr. Crumble had to get on to a device that would allow him to reach above his head and would allow him to put the sheetrock into the ceiling. Now, ladies and gentlemen, that device was not something that he brought with him to the job site. That was not something that he had on a tool belt. That was something provided to him by these defendants as part of their contractual obligations to one another. And that was a baker's scaffold. And you'll hear that term throughout the course of the trial. And simply stated, a baker's scaffold is a scaffold that is on wheels so that it can be moved from place to place, room to room. So it's got 4 wheels at the bottom, and you'll see pictures of it. 4 wheels at the bottom, takes you up a height. In this particular case, it took up about 8 feet high and allows room to work. This particular scaffold, ladies and gentlemen, was 4 feet by 8 feet and had 4 sides. Well, the evidence is going to show you in this case, ladies and gentlemen, that at the time of this accident, only 2 of the 4 sides were protected. In other words, there are railings that go into the scaffold. You can lift them out and put them in. And when you're working at a height, clearly you want to have a railing that completely surrounds you. But what was provided, the evidence will show you in this case, by these defendants? What was provided was a scaffold with only 2 sides protected with railings. And ladies and gentlemen, the evidence will show that that scaffold, under our law, is defective, is not the appropriate and proper piece of equipment for this job. And that as a result, Mr. Crumble paid the ultimate price while doing his construction on that day. Now, during the course of this trial, you will hear evidence about what happened. And the very first witness that you'll hear from after lunch today is Mr. Kroller. Mr. Kroller was the site safety foreman who worked for the general contractor, Crispy Construction. Mr. Kroller is a certified site safety director, and the contracts obligated Crispy to have a Mr. Kroller type person on the job site. Mr. Kroller was responsible for all of the safety on that site, which included making certain that all New York State industrial codes were met, that all OSHA standards were met, and that the contractors were all complying with the industry standards for a safe place to work. That was his job. And you will hear from him this afternoon. And he will be cross-examined by my colleague, Mr. Torgan. And he will cross-examine him, and I'm going to tell you, I'm going to give you a little preview, because we took his deposition in this case. So we know a little bit about what he's going to say. Mr. Kroller will be forced to admit to you. Again, the defendant will be forced to admit to you, first, that a proper scaffold must have four sides. It's not just Hershenhorn talking, that is fact, and you will hear it from the defendant. You know what else you'll hear from him? And he might fight, and he might try to wiggle his way out. And I ask you in jury selection to not mind if you heard some harsh cross-examination of him, but he will be pinned down, and he will admit to you that a scaffold without four railings is defective. That a scaffold without four railings does not comply with the industry standards and the prevailing laws. And guess what, ladies and gentlemen? This accident happened late in the day. It happened at around 3:45 in the afternoon. What does that mean? Well, it means a few things, but one of the things it means, the evidence will show, is that Mr. Kroller was on that job site from 7 in the morning until 4:30 in the afternoon. The work is going on floors 3 through 8. It's not a huge amount of territory, although each floor is 20,000 square feet, but it's not a huge amount of territory for him to cover. Where was Mr. Kroller that day? What was he doing? He knows that that was a dangerous scaffold. Why didn't he stop Mr. Crumble from working, or make sure that Mr. Crumble had the right and safe scaffold to work on? Well, those are questions that he will be forced to confront later on today.